My name is Fiona de Londras and I'm the Professor of Global Legal Studies at the University of Birmingham. As part of my work on human rights and human rights law, I have a background in working in abortion law reform, having been especially involved in the recent reform in Ireland and currently working with colleagues and activists in both Northern Ireland and Gibraltar to try to reform and improve the law there to make lawful abortion available for people who need it. In the last few days, a lot of attention has been paid to a new abortion law that's been passed in Alabama in the United States. Now, this law, which introduces a near total ban on abortions with very heavy penalties for doctors or medical professionals who provide or attempt to provide abortions, is indeed an extreme anti-abortion law. It is preceded last year in Alabama by a change to their state constitution that recognized what it called the sanctity of unborn life and the rights of what it called unborn children, including the right to life. So this new law in Alabama is in a way an attempt to give effect to that constitutional change at the state level. The law was signed into effect by the governor last night, but it's pretty clear that it's going to be challenged almost immediately in the courts. Indeed, this Alabama law is one of dozens of laws introduced over the past few months in states across the United States, trying to roll back on the availability of lawful abortion across the US. These laws vary. Some are what are known as Tract Laws, or targeted regulation of abortion provider laws. So they don't say that abortion is illegal per se, but they make it extremely difficult legally to provide abortion. So they might require a doctor to have admitting privileges in a hospital, or as in some cases require you as a pregnant person to have an ultrasound, to look at the ultrasound, to hear a fetal heartbeat, and then to take a waiting period before you can access abortion. All of these kinds of laws are designed to try to make it extremely difficult emotionally, medically, logistically to access abortion, the access to which is a constitutionally protected right in the United States. Some other states have taken different approaches. In particular, a number of recent state-level laws have been what they call fetal heartbeat laws. So that is laws that would ban abortion once a fetal heartbeat, so-called, can be heard, sometimes defining that as early as 6 or 8 weeks into a pregnancy, when a lot of women don't yet realise that they are in fact pregnant, especially if their periods are irregular or they're on long-lasting contraception that stops their periods, but where it has failed, they're pregnant and they don't realise it because they don't in any case menstruate on a regular basis. And then you have a law like in Alabama, which is an attempt at an outright ban. The idea behind all these laws is both, as I've already said, to try to make it really difficult to get an abortion and to try to force the courts in the United States to revisit an important case from 1973 called the case of Roe against Wade. That's the case that said that there is a right to access abortion as part of your right to privacy in the US within the first trimester, more or less, of pregnancy. That case also said that states can regulate abortion. They just can't regulate it in a way that makes it impossible to exercise that constitutional right. And in a later case, which people don't know as well sometimes, which is called Planned Parenthood against Casey, the court said the test was whether or not a law placed an undue burden on a person's ability to access abortion. If it did, it was unconstitutional. If it didn't, it wasn't. So these states are all trying to set up cases that would ask the United States Supreme Court to revisit these important decisions like Roe against Wade and Planned Parenthood against Casey in order to try to narrow, if not eradicate, the constitutionally protected right to access abortion care. People are rightly upset and outraged about the introduction of these kinds of laws, not least because many people consider access to abortion to be important for women to exercise their human rights. Many people believe that what we do with our reproductive lives is a matter of our own private decision making, and many people believe, frankly, that life is difficult and messy, and that sometimes people need support to make decisions that are right for them and their families, and that the law's job is to provide that support rather than to make life more difficult by banning abortion or making it impossible to access. And for many people here in the UK, it seems extremely difficult to understand how laws like this could be passed. And that's not least because in most of the UK, abortion has been fairly accessible since 1967. But we have to remember that there is a part of the United Kingdom where the Abortion Act has never applied, where abortion is not available unless it is to save the life of the pregnant person, or that person would be a mental and physical wreck, that's the test, unless they could end their pregnancy. And that part of the UK is Northern Ireland. Abortion is a serious crime across all of the UK, but in England, Scotland and Wales, there are exceptions to that crime that mean that for most people, abortion is available. Those exceptions do not apply in Northern Ireland. Even though women, girls and pregnant people living there are citizens of the UK, get their healthcare through the NHS, pay their taxes and have representation in Westminster, they do not have the same rights to access abortion care as people in other parts of the UK do. This has been recognised as a violation of human rights, and still no reform has been introduced. Now, abortion is a devolved matter. That means it is a matter that should be legislated for by the Assembly in Northern Ireland and not by the Houses of Parliament in Westminster. But there are two problems with that. The first one is that the Assembly doesn't sit. It hasn't sat now for a long period of time, around 2 years, so that there isn't a Parliament in Northern Ireland that can act to give effect to the rights of pregnant people there. The second problem is that the criminalization of abortion, and by the way, in Alabama, a person who has an abortion will not commit a crime under this new law. Here, in the UK and in Northern Ireland, you do. The law that makes it a crime is a UK-wide law. It's called the Offences Against the Person Act from 1861. It is possible and desirable for the Parliament in Westminster to just repeal the two sections of that act that make abortion a crime. Abortion then would not be a crime for pregnant people anywhere in the UK, including in Northern Ireland. Medical professionals agree that that's the best thing to do. Human rights tell us that that's the right way to proceed with regulating abortion. And pregnant people tell us that when abortion is a crime, it doesn't stop people having abortion. It just stigmatizes it and drives people into illegality. And so if you are, as I am, disappointed and upset at the introduction of these laws in the United States, if you think that they fail to give effect to the human rights and the constitutional rights and the dignity of pregnant people who, for whatever reason, cannot continue with their pregnancy, then it might be time also to think about whether people living in the UK also have the ability to make decisions about their reproductive lives. Why it is that women, girls and pregnant people in Northern Ireland have fewer rights than people in the rest of the UK, and what it is that you think you can do to try and make a difference if you don't think that that is right.